Good afternoon, counsel. Nice to see you both. Sorry it's so dark, but can you both hear me okay?
I can, Your Honor. David Fitzgerald,
Okay,
yes.
all right, great.
Good afternoon.
Yes, Your Honor.
Good afternoon. Let me call the case. This is the time set for hearing on a joint statement of a discovery dispute pursuant to Rule 26D. It is CV 2025-06953. I'll begin with the appearances of counsel. And Mr. Fitzgerald, before we go further, could you tell me how to properly pronounce your client's name?
I'm not certain about the first name, Your Honor, but the last name I pronounce Beige.
Beige, okay. And please announce for Dr. Beige.
Yes, Your Honor. David Fitzgerald on behalf of the plaintiff, Dr. Beige.
Thank you, counsel. And then Ms. Ronan, on behalf of the defendants, I assume that you and Mr. Bookspan represent Ms. Waddle, the estate, and the LLC as well?
Ms. Wattel, yes, all of them.
Wattel. Okay. Please tell your client no disrespect intended, but I'm going to make a note rhymes with Mattel, so I remember it next time. Okay. Well, nice to see both counsel. Just so you know, obviously I've read the 26D, but I did go back through and I read the entire case file so that I would be familiar not only with the matters raised in the complaint, but with the procedural posture of the case. And I did see that there are three issues that are raised by the joint statement. I also saw that the parties, and it looked like both sides, were asking for some additional briefing on this. But if I could just get the lay of the land as to where we stand now, Mr. Fitzgerald, at least on behalf of Dr. Beige, has anything changed since the filing of the 26D?
There's one issue that has not changed in terms of resolution, but it's lightly touched upon in the paper, which is my client wished to subpoena MasterCard and American Express. The defendants objected to that subpoena, and we were about a week away from today's hearing. They objected to the extent it had anything to do with Desiree or David Wattel individually as opposed to the entity. And I think in their response, it's lightly touched upon. So we may, if we could, get a resolution of that particular issue while we're at it today, then we'll know how to proceed on that front as well.
Well, we can try, but Ms. Ronan, from what I saw in the papers, part of the concern is that your client has perhaps one or more other ventures and takes the position that the financial workings in those other ventures are not relevant to the present dispute. Is that roughly accurate?
Yeah, I think that is accurate. I think Rising Cloud has done a great job of running as a very clean company, and we don't think that there is any evidence that suggests that it should go outside of Rising Cloud. So until Mr. Fitzgerald can point us to something to suggest that it's worth invading our client's personal financial information, we have taken the position that that we believe that is unacceptable for him to cross that legal barrier without more than just a complaint. And we can get into that more, but that is our position, that the personal financial information of the Wattels should not be at issue in this litigation.
Okay. Well, let's talk about the first issue raised by the 26D, and that pertains to, now I don't know if it was Ms. Wattel's personal computer, the late David Wattel's computer, or the LLC computer, but there is at least an allegation that the contents of that drive have been lost. Ms. Ronan?
Yes. So we have produced an email to Mr. Fitzgerald when he was questioning us about it. We explained to him that this is what we know, is that the QuickBooks and the backup for the company was put onto a flash drive. And the flash drive, our understanding is that the flash drive is corrupt. Ms. Wattel had people in her office at the time try and gather the information off the flash drive. They were unable to do so. So we advised Mr. Fitzgerald that that was the lay of the land.
So that could represent a significant loss of at least relevant financial data. Do you agree or disagree with that?
Well, I think what's important here is that we have produced all of the bank statements for the company from the inception of the company to the winding down of the company. So that we have produced bank statements for an entire 6 years the company was in existence, which shows the money in the door and the money out the door. And in addition to that, we've produced the profit and loss statement that Ms. Wattell was able to get access to as of May 3rd, 2024, as well as a balance sheet as of May 3rd, 2024, and a couple other documents showing who were the investors and what their interests were. So we also found through Mr. Fitzgerald's subpoena to Aptus, which is another member of Rising Cloud, a P&L statement for 2021. So what we're finding is that the information is slowly starting to come out, but it's also our position that he has the information he needs if he wants to see what money went in and went out of the business. He has access to that information. So that has been our position on it, and we think that as more discovery is done, as he's asked for tax returns, he has subpoenaed the accountant for the tax returns. I don't know if he's received them or not. I just think there's a lot still going on that we're not objecting to him getting access to the Rising Cloud information. We just believe that going into the personal information is where there's a hard stop. So is there missing information? Possibly. Do we know for sure today? No, we do not, as more information is being uncovered from the amount of discovery that he's doing. So it's our position today that this is a little premature, given that discovery is not closed and he has not deposed our client, Ms. Wattell.
All right, thanks, Ms. Ronan. Mr. Fitzgerald, if you could clarify one thing for me. So looking at the complaint, the allegation was that your client had purchased, I think the language was, some units in the predecessor to Rising Cloud. Was your client, in fact, a member of the LLC, or were these simply investments that he had made?
Your Honor, my client made two $500,000, wrote two $500,000 checks to, I thought it was Rising Cloud, but the predecessor of Rising Cloud is a company called Stratum LLC. Right. It's the same company. It's just renamed. It's exactly the same company. And so it's just Stratum has been renamed Rising Cloud, just to make that clear. The membership of Rising Cloud, according to the Arizona Corporation Commission, is, or at least was, Desiree Wattell, David Wattell, and Aptus Engineering. So this is a member-managed LLC, and it's supposed to, as I recall from Arizona LLC statutes, when you're member-managed, the ACC information is supposed to list all the members. So he's only been treated apparently as, well, his status is a little bit unclear. We've alleged that he's both an investor and a lender, that he loaned $500,000 and he invested $500,000. We don't have an operating agreement from the company to say how they treated him. So I'm not sure if I've answered your Honor's question, but it's a little more complicated, I think, than your question.
And it sounds like you're telling me that your client does not have any documentation as to his status with the LLC, which seems candidly a little odd given the amount of money that was invested and loaned.
Well, he has the two checks that went to the company. We just did get information from Chase to show that those two checks were deposited into Rising Cloud. So he's clearly got $1 million into the business. The operating agreement, I would have thought that it would have been an exchange, but we didn't represent him at the time. So on an exchange of the operating agreement or the promissory note or what have you, that would have accompanied the provision of the $500,000. But at this point in time, we have, I think, some emails and the check copies themselves, which again I can say with virtual certainty they were deposited into RFL and perhaps Stratum. In terms of what we have, the P&L and balance sheet that were provided were at the end of the business, effectively when it dissolved. So how did we get from a company that it looks like through the bank statements processed about $6 million of inflows and then had about $6 million of outflows, and we only have, well, here's the closing, the bank accounts are all gone, there's nothing there, and there's some very strange entries with respect to how we got, how did it go through this $6 million? Are these all legitimate third-party expenses, or did they prefer themselves, they being the Wattels and or Aptus, to the other members and creditors of the business? They are allegedly, the Wattels loaned money to the company and then took money out. We've not been provided any promissory notes, any loan agreements, anything showing that they actually put any money in at all, let alone that they lent it. So we have asked for their side of the financials to show, at least with respect to Rising Cloud and Stratum, do their financial statements reflect these things as loans? Do their bank accounts show this money going to Rising Cloud? Because bank statements generally don't have all the information you need to, it may have a deposit and a date, but it ordinarily doesn't have who made the deposit, or conversely, who made, where did the withdrawal go, especially with electronic transactions. So there, I believe, and according to the loan statement, which again, it's sort of like, it's almost like a balance sheet or a ledger that says, okay, this monies were loaned. The Wattels are claiming they must have loaned money to the business and taken it back out, but they have nothing other than one single piece of paper to show all this activity. Well, their own financials, bank statements, tax returns, things of that nature should show their side of the activity with Rising Cloud. If they have other businesses that have nothing to do with Rising Cloud and that are on their financial statements or their own cash accounts or tax returns, we have a confidentiality order. They can designate it as confidential, or even if it's attorney's eyes only, we have that provision as well, that they can rely on so that this information doesn't get, spread around the world willy-nilly. But there are mechanisms to protect their privacy, and we have it built in this case. And so okay, when we had to subpoena these entities, let's call it out in the last week, we might not have had to do that had they produced their own stuff without the subpoenas, but they're taking the position their own financials, they being the Wattels, are not relevant to this proceeding. And I disagree wholeheartedly with that. We allege in the complaint that monies have gone to other creditors and other members without going to my client in breach of fiduciary duty. That is a breach of fiduciary duty claim. It's not a piercing the veil type claim. It's a direct claim. The member who's in charge of the entity wrote a check to himself instead of to pro rata to all the members. That would be quintessential breach of fiduciary duty. It has nothing to do with piercing the veil.
Okay. What's the status of the subpoena for the tax records?
It's out the door, Your Honor. I'm not sure when the response date is. It should be pretty soon, if it's not already too late. I would not be at all surprised if we have received an objection, because this is the accountant for the business, and Arizona has a very strong accountant-client privilege. But this is a document that the defendants should have produced to us without us having to subpoena the accountant. This is a document in their possession, custody, or control. Should have been produced already. And but there was no objection to our subpoena, as I recall, to our subpoena to the accountant, but for those records at least. But we don't have the name of the accountant for for the Wattels individually. So I don't know if it's the same person or not. So that person has not been subpoenaed.
Okay. All right. Back to you, Ms. Ronan.
Sure. So I'm going to just kind of go back to my point that this is a little bit premature. What he did was subpoena Aptus. One of the things that he's done is subpoena Aptus, which is another member of Rising Cloud. Aptus's subpoena production, which he did produce to us, is about 3,000 pages long. In those 3,000 pages is the operating agreement for the company, which he has. In those 3,000 pages is correspondence discussing that that the second $500,000 investment just going to pull it up here. The second $500,000 chunk of money that his client invested is going to be paid out at $600,000 reimbursement at the time of sale.
Yep.
So I think there is information in here that is pertinent to his claims that maybe we haven't gone through yet and discovered. As far as the tax returns go, we did attempt to acquire the tax returns for Rising Cloud. The accountant was unresponsive to us. We supported Mr. Fitzgerald's subpoena to the tax to the accountant. We have not objected at all to any attempts or requests or anything that he's trying to do with respect to Rising Cloud. As far as the personal information of the Wattels, I would go back to Dave Wattell was involved. He was an entrepreneur. He was involved in many other businesses. Was a lawyer in town. He was a co-founder of a respected personal injury firm here in the Valley. Miss Wattell is also an entrepreneur and involved in things. She's a real estate agent. They have a lot going on in their personal business, to which this is completely unrelated. And if I have gone through the bank statements, every single one of them that we have produced, and from the bank statements alone, I can tell that the Wattels have personally invested over $2.3 million from one bank account into the company, and they have only received approximately about $157,000 back into that account. So the bank statements are very clean. This is not a complicated company. It is a startup. It was a startup that did not get going. And unfortunately, Mr. Wattell, who was co-founder and the CEO of the company, he passed away from cancer 10 days after they closed the doors. He was the one who negotiated these agreements. He was the one who was involved in all of these. So Mr. Fitzgerald is correct that, the initial investment of his client is not particularly well documented anywhere. We have loose emails. It was probably more of a loose exchange. No promissory notes have been put out there. We do not believe that it was a loan. The operating agreement states that he had a 2% interest in the company. This is an investment gone bad in a startup. And the Wattels also lost millions of dollars in this investment. So we just think that going down this path of trying to figure out whether or not the Wattels, looking at the Wattels bank statements to determine if the money from their bank statement went into the Rising Cloud bank statement is wholly inappropriate when you can see the Rising Cloud bank statements that show this amount of money was deposited from this account. Now, if he doesn't understand which account relates to the Wattels, he is welcome to depose Desiree and ask her if this is her account or if this is the amount of money that she put into this account. He has not done so. So I think the path of least resistance right now, at least, is to depose Desiree if he has questions about it and walk through it. But I think we're going to find that the evidence does not support what he's trying to prove. And there's nothing there. He has pointed us to nothing to suggest that invading their privacy to this level is worth it in this situation under these circumstances.
May I be heard, Your Honor?
You may.
I just heard that there was $2.3 million from some other account that came from the Wattels that supposedly went into Rising Cloud. We don't have that account information. We don't have inflows. I don't know if that $2.3 million came from the Wattels or from some other third party. I mean, if they want to claim they invested 2.3 million, and therefore when they took out less than 2.3 million, there was no breach, they should have to show that they invested $2.3 million into the entity before they started taking monies out. The operating agreement that I heard, it's either, as I remember, an unsigned agreement, or we don't have, or it's an amended